Hi, good afternoon, everybody. Welcome to today's webinar, Avoiding Common Teaming and Subcontracting Pitfalls. And I guess I should wish everybody a happy No More Government Shutdown Day. Appreciate you taking time out of what's probably become a very busy day for you as you're getting back into the swing of things, hopefully, after the shutdown. Appreciate you taking some time out to join me for this webinar. I'm only going to be on camera here for a brief moment. We are re-recording this webinar. We originally gave it a few weeks ago, but unfortunately we had some audio issues during the recording. And so we're re-recording it today. I'm going to turn off the camera so that we can try to optimize the audio as much as possible. If you missed it the last time, then great. You're here. Appreciate you joining. If you tried the last time and you couldn't really hear things very well, or you dropped off early, I apologize for that. But we're going to get another opportunity here to talk through common teaming and subcontracting pitfalls. So let's go to the next slide. All right, so this is me. You got to see me live in the flesh there briefly, and just a little bit about what I do in our government contracts practice group here at Piliero. I'm coming up on 20 years at Piliero, and I've been part of our government contracts group that entire time. It's a full service government contracts group. We're doing everything from protests to investigations and transactional matters like joint ventures and teaming agreements, M&A, FAR compliance. I mean, it really runs the gamut what we do in our government contracts group. And as we pull up the next slide here that talks a little bit more about Piliero as a firm, the reason that I wanted to do this webinar is because a very common project that we work on in our government contracts group is helping clients with teaming agreements and subcontracts. These are probably the most common agreements that we help contractors put in place. I'm sure for you all on a day-to-day basis, it's one of the most common type of agreement that you're dealing with. And let's go to the next slide and just get into the overview for today. So what I wanted to do was share sort of the lessons learned and what kind of the war stories where we've been through situations, because we've been in a lot of different situations where disputes arise under teaming and subcontracting agreements. It's hard on the front end to anticipate every type of issue that you could potentially get into, but the objective when we're drafting a teaming agreement or a subcontract is to try to plan for the rainy day. Let's try to anticipate where things could go wrong in the arrangement and try to put in place provisions in these agreements that will protect you as much as possible or possibly avoid those disputes altogether. So, that's really kind of the genesis of this webinar, is to walk you through these war stories, experiences, so that you'll get some tips. So when you're working on your teaming agreements and your subcontracts, that you can hopefully benefit from these lessons learned that we and other companies have been through over the years. And everybody is going to get a link to the recording after this is over with. Hopefully it'll be much clearer from an audio perspective this time than it was the last time around. And you should feel free to use the question box on your screen there to fire away questions throughout the webinar. The last time, what I unfortunately can't recreate this time is the Q&A that we had. We got a lot of good questions last time from the people who attended, and I tried to answer as many of them as I can. So unfortunately, I won't be able to recreate that here, but I am happy to take your questions today. So anytime you think of it, just fire it in and I'll get to it as many as I can during the presentation. And let's go to the next slide and let's just dive on in. So we're gonna, I focused in, we can't cover all types of disputes that arise in an hour, but I focused us in on some key areas. And before I get into those key areas, I just wanted to make sure we're all starting from the same place on the basics. So the teaming agreement and subcontracts, like I already said, are probably the most common agreements you're going to deal with as a government contractor. If they're working the way they should work, the teaming agreement comes first, and then the subcontract comes later once the prime contract's awarded. Ideally, before work starts, I realize, I get to say what's ideal, and you have to deal with the real world. And a lot of times, you may need to get started on the work before the subcontract's in place. I would just say as a best practice, we want to have the subcontract executed before work starts. If you have to do an ATP, where you get authorization to start work with the subcontract coming later, I understand why you would make a business decision to accept that. And I don't think that's the end of the world, but ideally we want to have the subcontract in place before work starts. We want to have them in writing. That probably sounds like a very basic point, but you'd be surprised how often situation comes to us. There's a dispute between teaming partners and they don't have a written agreement, and that's not necessarily going to make it impossible to handle the situation. There can be agreements that are enforceable and are not in writing, but it certainly makes things more difficult if you don't have written agreements. And really, this last point I think is key for teaming agreements. If you have a well-drafted teaming agreement, that should pave the way for the subcontract. In other words, like the teaming agreement is kind of laying the foundation for how you're going to work together on the project if you win the work. And ideally, if you're going to go through the effort to negotiate a teaming agreement for the project, you'd like to avoid having to renegotiate terms when the prime contract is awarded. I mean, there are probably going to be certain things that you can't address at the teaming agreement stage because you just won't know until the prime contract's awarded. But there's a lot that you can kind of pre-agree on at the teaming agreement stage to simplify the process when the subcontract is ready to be awarded and you're ready to get started for work. So that would be the objective of the teaming agreement, make it smoother when we get to the subcontract stage. All right, let's go to the next slide. And, an ounce of prevention really does go a long way, when it comes to these agreements. What I mean by that is, that you've really worked on them, make them as strong as they can for you before you sign. If you come to us with a dispute with your teaming partner, one of the first things I'm going to say to you is, all right, well, show me the teaming agreement or show me the subcontract. Because at that point, if I'm going to get into a dispute arena, whether it's court or arbitration, it's going to largely rise or fall on the terms of the agreement. And for the most part, we can't rewrite the agreement at that point. We're kind of stuck with what you already agreed to. So it's just, the best way to avoid issues is to address them up front. There's just so much more that we can do if you involved us on the front end. And I think, that doesn't necessarily mean that it has to be a very extensive amount of legal review for a teaming agreement. I think clients probably would generally not think that's a worthwhile investment, but an hour or two to have your outside counsel take a look at the teaming agreement before you sign it and make sure there's no major red flags or what's going to happen if this doesn't work out the way that we're hoping it works out. Like you're being asked to sign up to be exclusive for the next 2 years to one company. Well, what are you being promised in that agreement? And I just think that hour or two, that ounce of prevention is worth a pound of cure, because after the fact, if you're not happy with that agreement, it's probably going to be a more expensive and maybe a less satisfactory resolution than if we were dealing with it on the front end. So, boilerplate, it matters, so don't gloss over it. don't be afraid to push back on one-sided agreements. I think when we represent a company that asks us to prepare a template for them for a teaming agreement or subcontract, that this is a common project where they'll say, help us put in place a standard subcontract so that every time we need to issue a subcontract, we've got a good solid base that we're working from. When we do that, a lot of times the contractor wants to have very one-sided provisions, very favorable to them. It's their agreement. I think that makes sense. But there's sort of an understanding that certain provisions they might be willing to give on. If the other side pushes back, they may be willing to give. And I do remember that the first time we gave this webinar, there were several questions about like, well, what's the track record or the likelihood of succeeding and pushing back on a one-sided provision if the company on the other side is a really large contractor? And I think the answer, what I said then, and I'll say it again here, is it definitely depends on the contractor on the other side and what the issue is. Some large firms are going to hold a very hard line and be unwilling to give on maybe anything in their standard agreements. But I think in my experience, when we get involved in the negotiations, I think there's a couple of benefits there. Number one, then the other side knows you have competent and experienced government contracts counsel looking out for your interests. And number two, we're not going to advise you to push back on insignificant issues. I think you'd probably be wasting everybody's time if you're pushing back on every other provision in the agreement. A lot of times you do need to hone in on what are the really important issues here, the key points. If we can't rewrite this whole agreement, they won't have us on their team if we're trying to rewrite their whole agreement. So we've got to try to be targeted in what's really important, what's going to have the most impact on how successful this arrangement is for us. And then you have to ultimately make a business decision. If the other side is refusing to give even on those provisions that are really critical to you, that's where it becomes a business decision, whether that team is the opportunity outweighs the potential downside that the agreement isn't as favorable as you would like it to be. I added this bullet here at the end about vague provisions because I've just run into this situation a lot where I think there's a bit of a misnomer that some companies might think that it's to their advantage to have vague provisions. And I understand the thinking there, but I think a lot of times it doesn't actually work out to be advantageous to have vague provisions, especially if we end up in a dispute. If you were the one that drafted the agreement, a vague provision can be interpreted against you. And even if you're not the one that drafted it, or maybe the law in that jurisdiction isn't going to hold it against you as the drafter, it's likely to make the dispute resolution process more complicated, because if we don't have a clear understanding of what the requirements are. And I think this is often where disputes arise, vague provisions, or they're capable of multiple interpretations, and nobody, including us, has yet been able to write a perfect subcontract or teaming agreement. There's always going to be issues that sharp lawyers can find in these agreements. But going into the arrangement, if there's a key provision that's not as clear as it could be, most of the time my advice is going to be, let's clear up that provision. Let's take the ambiguity out. It's going to be probably to everybody's best interests in the long run. All right, let's go to the next slide, and just reminder, feel free to fire away on questions if you have them. So another basic point at the outset is just to remember what hat you're wearing. There are going to be differences. There should be differences in these agreements, depending on whether you are the prime contractor or the subcontractor. You're going to have different interests. You're going to have different obligations. different objectives. So I think the best practice would be to develop templates for the agreements, versions that you like when you are the prime and when you are the sub, assuming that you play both roles. Obviously, if you're only ever a sub, then you wouldn't really need the version that's favorable to a prime contractor. And frankly, if you're only ever a sub, you may not very often be in a position where you get to give the other company your agreement. You're probably more often going to be in the situation where you have to receive the other company's agreement. But if you're both a prime and a sub, I think it's nice to work towards having a couple different versions of your standard agreements that you like, and at least make sure that you're tracking on the fact that there are different considerations, and circumstances where if you're the prime, maybe you want something to be one-sided, versus if you're the sub, you're going to want it to be mutual. I do remember that during the last webinar, somebody asked, well, what are some of the common provisions that would be one-sided if you were a prime, or you might want to be mutual if you were a sub? And some common examples there are like indemnification. I would say it's not uncommon that the prime contractor agreement might only require the subcontractor to indemnify the prime. But if you're the sub, you would want to push for that to be mutual. If either party does something like gross negligence that results in significant injury or death, then that party should indemnify the other party. I mean, that's the subcontractor's perspective. And so again, it depends on what hat you're wearing. But I also completely understand why, as a prime, at least your going in position may be, we're not going to sign up to that with respect to the sub. It's this, the sub wants to be hired by us. They've got to agree to indemnify us. So a lot of times that does start as a one-way provision. And some other provisions like non-solicitation and non-competition I've seen go one way in a prime agreement versus mutual in a subcontract when you're the subcontractor. Limitations on liability under the agreement. I think a lot of times primes will want to start off with having only the subcontractor be limited in terms of like the prime's liability to the subcontractors. What I mean there, the subcontractor will be limited in what they can recover from the prime, versus if you're the sub and a prime is insisting on limiting their liability to you, I think in many cases it would be reasonable to push back and say that should be mutual. What's good for you should be good for me as well. So, all right, let's go to the next slide. All right, so a little bit more about teaming agreements. So, to agree or not to agree is really the question for teaming agreements, because this gets to the heart of whether the teaming agreement is enforceable or not. And I think there's probably a threshold question there, like, do you care if the teaming agreement is enforceable? Do you want it to be enforceable? And that may go back to what hat are you wearing, and there may be circumstances where you're okay with the teaming agreement possibly being difficult to enforce. And there may be other circumstances, depending on what hat you're wearing and the project and the parties involved, where it's critical for the teaming agreement to be enforceable. This is, probably the first question that we go to when somebody brings us a dispute under a teaming agreement, is whether we're going to be able to enforce the teaming agreement for whatever issue has arisen in the dispute. Because it can be challenging to enforce a teaming agreement. Virginia especially has some case law that it's tough on agreements to agree. So if the teaming agreement is simply an agreement to agree again in the future on a subcontract, then it's going to be more difficult, especially in a jurisdiction like Virginia to enforce the teaming agreement. But so it also depends on what aspect of the teaming agreement are you trying to enforce. You know, I mentioned exclusivity at the outset, which is a common part of teaming agreements. That probably would be enforceable in most teaming agreements because that's not usually written as something that you have to agree again upon in the future. That's an agreement today, right now. We are agreeing to be exclusive together for this particular contract. The aspect of the teaming agreement where you get into trouble with it just being an agreement to agree is the commitment for a subcontract. Because a lot of times the teaming agreements have kind of wishy-washy language about whether a subcontract will be issued. And I've given you some examples here in the last bullet. You know, sometimes the teaming agreement will just say that you'll negotiate in good faith toward a subcontract for 60 days. That's an example of what I would consider to be wishy-washy. You know, you're not committing to issue a subcontract if you're the prime using that language. You're just committing to negotiate in good faith. And the result of a good faith negotiation could be no subcontract. So as a subcontractor, you wouldn't like that language. Well, like maybe you would be okay with it if you were the prime. And then on the other hand, you could have more definitive language like the parties shall enter into the subcontract within 7 days after award. You know, if you were the sub, that would be, you know, that's the kind of language you would want to push for because that's more definitive. I mean, frankly, if you're in Virginia and you're really concerned about ensuring the the teaming agreement is enforceable in terms of a commitment to issue a subcontract, you're going to want to have language like shall enter into the subcontract within 7 days after award, and ideally you'd have a copy of the subcontract attached to the teaming agreement with most or not, if not all, of the key terms already nailed down. I mean, that's kind of the belts and suspenders way to try to make the subcontract commitment enforceable, at least in Virginia. Let's go to the next slide. Yeah, thank you. So, all right, so that's the basics. And I'm going to turn now to the first type of common dispute that we see, which is with respect to work share. And I mean, it is probably the most important part of these agreements, right? You know, how much of the work are you getting? How much of the work am I getting? What type of work are we each going to do? So what I have on this slide is just some examples of the types of issues that walk in the door for us. You know, clients call us and say, I've got a dispute. I'm not getting the work that I thought I was going to get out of this project. And so we say, all right, well, send us the teaming agreement or the subcontract. And then we see that it doesn't specify work share at all. There's nothing in the agreement. And it turns out that the understandings of the parties about work share were just from conversations. Maybe they were in emails, but it's not actually in the agreement. Another common issue we see is that the work share term is non-committal. And trust me, if you're the prime, if you're wearing the prime hat, I understand why you write it this way. It's just you have a different perspective on this if you're the sub, and all the prime is committed to do is to strive to give you up to a certain amount of work. So from a contractual standpoint, if you're in a dispute, it's kind of hard to say that prime, what did that prime really commit to give you then? And then how do you prove that they breached that commitment when the commitment was kind of vague and broad like that? So that's a pretty common issue. We've seen a lot of examples of the subcontract work share requirements not consistent with the teaming agreement. Once you sign the subcontract, then the subcontract typically is going to override the teaming agreement. The teaming agreement, you know, may not even exist or govern anymore. So that's why it is important if you're doing the subcontract and you had a teaming agreement, refer back to the teaming agreement. Make sure that the subcontract draft lines up with the teaming agreement. Like I said before, the whole point of the teaming agreement, or a large point of it, is to pave the way for the subcontract. we shouldn't be having to renegotiate things that we've already agreed on at the teaming agreement stage. And I realize, there are some caveats to that, but as a general rule, we don't want to have to cover the same ground we've already covered in the teaming agreement. So you should be on the watch for a subcontract draft that comes your way that doesn't line up with what you've already agreed on in the teaming agreement. Yeah, so subcontractor raising rates between the TA and the subcontract phase, that's not uncommon either. If you don't have any provisions in your agreements addressing that, you may have a hard time resolving that. Let's go to the next slide. If we've got a small business prime, we've seen issues where they've committed to do work that they just simply can't perform, or they will not perform enough of the work to be able to comply with the limitations on subcontracting. That's, I would say, become recently, we've had multiple disputes centering on that particular issue. So I don't know if there's just something in the water or that's becoming a more prevalent issue. We've got teaming agreements that don't assign discrete portions of the project. That's more of an issue in the past than maybe it is now, because there's a particular type of affiliation that we're concerned about there, which is called ostensible subcontractor affiliation. And I don't want to say relaxed the ostensible subcontractor rule, but they've just made some changes to it that make it, I think, maybe less of a concern, but still, as a general rule, good idea to be assigned discrete portions of the work to the subcontractor so you can avoid that type of affiliation concern. And also, it's just better from a business standpoint to be clear on who's doing what, rather than just saying we're all going to do everything. It's better to say, well, the prime's responsibilities are ABC and the sub's responsibilities are XYZ. All right, let's oh, I'm sorry, before we go, yeah, this last one, the adding a new team member that affects the work share of the pre-existing team members. If the prime will probably have discretion to do that. And when you are the prime, you're going to want the discretion to do that. So I think the question is, does the teaming agreement allow you to do that if you're the prime? Do you have to kind of rebalance the work share to make sure that the sub is still getting what they were expected to get? Or can you change the sub's work share to account for the fact that you've got to bring on a new team member? When you're the prime, you need to do what the government customer wants. But a lot of times the government customer isn't going to tell you exactly how to accomplish it, right? Or they're not supposed to be that specific. So you have to have the flexibility to make it happen, whatever the customer wants. And that can include sometimes bringing on another company into the project. And then that can create issues with, well, how do we deal with the companies who are already there, and whose work share does that come out of? And this can also go back to the limitations on subcontracting point that I mentioned. So yeah, those are some common issues. So all right, let's go to the next slide. All right, so now that we've established these common issues that we've run into, how do we deal with these things? And I'm happy if anybody wants to pop in like how they've dealt with this type of situation in the past. I can keep it anonymous if you want me to share, but it depends on what hat you're wearing. If when you're the prime, you're going to generally want flexibility, like for the reasons I was just mentioning on the last slide, because you've got to be able to say how high when the customer asks you to jump. And so you want to keep work share language flexible. You also want to make work share dependent on various factors to kind of keep your sub incentivized to be competitive, and also so that you can make changes based on customer needs. I think it's really important, if you are a small business prime, to leverage the limitations on subcontracting here. that is a requirement that you are under as the prime contractor. So you're the one who is on the line, so to speak, if you get out of compliance. And so I think that's a very useful tool for you to use in negotiating with subcontractors to say, look, we have to keep this work share where it is. We got to bring on a new partner, and it can't come out of our work share because we have to stay above 50% or whatever your limitation on subcontracting is. So I think it's a useful tool for leverage in negotiations, and it should be a part of your teaming and subcontract agreements. And yeah, I mean, this last point, just being careful about how you define the scope of work for large business subcontractors is, even though that type of affiliation has maybe the risk has lessened a little bit with recent changes to the rules, I still think this is a good idea. All right, let's go to the next slide. Thank you. So as a subcontractor, so now we've got a different hat on, throw everything I just said on the last slide, throw it out. We don't want the same amount of flexibility and vagueness in the work share requirements. I mean, I would say almost always. Maybe you would tell me there's certain sorts of circumstances as a sub where it's to your benefit to have more flexibility on the work share. But I think as a general rule, subcontractors that come to us with a dispute with their prime, it's because their prime isn't giving them the amount of work that they were expecting to get. And so if we're going to get into a dispute with that prime over the amount of work that our client was expecting to get, we want to have there be something very clear in the agreement that says how much our client was supposed to get. And so this little, greater than chain here, shall be is your best case scenario as a subcontractor. You want the agreement to say, my work share shall be 25%. Approximately 25% is not as good as shall be, but it's definitely better than will strive for 25%. Because at least, if I have to pull up a dictionary definition of approximately, I could show a court, or I could show the other side that we can't be that far off of 25% and still qualify as approximately 25%. But if all it says is will strive for 25%, I mean, they could basically drive a truck through that opening in terms of what they're actually required to give you. You as a sub, you want to resist the prime contractor having the right to unilaterally adjust your work share. If they have to bring on a new partner, we understand that. They're the prime. They got to do what the customer wants, but they should have to negotiate with you over the impact of that. I mean, you're a pre-existing member of the team. Presumably you brought a lot to the table to help the team win the work. So they shouldn't just be able to take your work share away unilaterally. I mean, that's the perspective of the subcontractor. It should be negotiated. So let's go to the next slide. I think this next point is really key. We're seeing this more and more being important because, like I mentioned before, there's more of a focus on limitations on subcontracting. More of an issue seems to be coming up around that point. So I think it's helpful for everybody on a small business set-aside project, the prime and the sub, to have a provision in your agreements that addresses how you're going to monitor and ensure the work share is achieved. I mean, I think that's a good idea, even if you're not subject to the limitations on subcontracting, but especially if you are. We usually write in quarterly or semi-annually, some fairly regular period where the parties are going to get together and see how we're doing. Are we on target? You're supposed to get 50% of the work, and we're halfway through the contract. Are you getting it? And let's check. Let's sit down together on a quarterly basis or an annual basis. Um, so having that already in the agreement. Yeah, I'm sorry. I'm just letting our office know. I guess there are some questions that have popped in, but I am not seeing them. So if you could please copy over the questions for me to see them. Thank you. And as soon as I see your questions, I will try to address them. So beyond the percentage of work, I've mentioned this a couple times already, but I think it's a good idea to talk about who's doing what. I mean, sometimes when we do joint ventures with that's a different topic, but you can get into real protest risk if you are not careful about the level of detail that you're describing the parties' work share responsibilities in a joint venture agreement. So we kind of go over the top there. If we can, we'll get into PWS sections and who's doing what. I don't know that you necessarily have to go to that level of granularity in a teaming agreement, but certainly at the subcontract stage, I mean, you just want to be clear. It's not just that you're doing 25% of the work. What actually are you doing? Because there might be more valuable, more better experience for certain types of the work, more profitable. And you wouldn't want to get stuck not being able to do any of that work if you thought you were going to get to do that work. But if you just have a percentage of 25%, but the agreement doesn't also specify what you're going to be doing within that 25%, then that I don't think that's optimal. So, and maybe you would say, well, when I'm wearing the hat of the prime contractor, then I don't care as much about getting into that level of granularity. It may be to my advantage not to get into that level of granularity. And I could see the argument for that. But I think the counterpoint, I may not lean too hardly on it if that's what you wanted to do. If you wanted to go vague and you're the prime, but it's going to reduce the possibility of disputes if you are clearer about what each party is doing. So I would just, you take that under advisement. Is it important to you to have a reduced potential for disputes? And you may want to be more specific. All right, let's go to the next slide. So I see here somebody commented, we have negotiated work share based upon certain specific IDIQ requirements, subject to the limitation on subcontracts or JV allocation requirements. Yeah, I mean, I think that those are the types of things that you should be aiming at when you're negotiating work share. I mean, and for small business prime contracts and for joint ventures, there are specific work share targets that you have to meet. So those do give you good targets to aim at. And somebody wrote, we always try to get a minimum of X% work share since up to can equal 0. And I completely agree with you. I mean, that the will strive for or up to, it just leaves open the possibility that despite our best striving, we didn't get beyond, just a few percent. And that's why if you're the subcontractor, at least you're probably not going to like that language compared to a minimum of X%. That's a much better way to do it. All right, so second category of common issues we run into, the term and termination. The term of the agreement is not clearly defined. This has happened several times over the years where one of the parties is arguing that we're still bound together for this project, even though at this point we're on a bridge contract or it's the follow-on contract. It's not even the original prime contract that we got together for, but the way the term clause was written in the agreement, it was at least capable of interpretation that that agreement remained in place for basically any future iteration of the program. And I don't really think that a company has a good position to try to insist that you're tied to them for any future iteration of a program, but you end up in a dispute if potentially if the agreement isn't clear. So we like to be very clear, and I'll give you a tip about that as we move forward. And that kind of goes to the same vein here on not having a term that's too broad. I mean, that also has gotten folks into disputes. And how does the term get extended? Does the prime have the unilateral right to do that? Or does the subcontract term automatically extend if the prime contract has been extended by the government? Agreement can be terminated for cause with no opportunity to cure. Yeah, I mean, I guess if you're the prime, that might be a position that you're aiming for. If you're the sub, you're certainly not going to want a provision like that. Let's go to the next slide. So more just these are just common issues over the years that when we've run into disputes that we've seen. It's like nothing in the agreement to specify what happens after the termination, or what happens if the prime doesn't submit a proposal. Do you have any recourse as the sub if you spend months working on a capture effort with your prime and spending a bunch of money on it, and then at the 11th hour the prime just says, nope, we decided we're going to no bid this? What's your recourse as a subcontractor? A lot of times there is no recourse in the agreement. That's what we've run into. All right, let's go to the next slide. So tips for how to deal with these common issues. I mean, I think it is best to spell out the reasons and the process for termination. Again, if you're making a passionate argument to me about why you think it's better if you're the prime contractor not to have very well defined termination processes, and I may not push back too hard on you, but I think for the most part, it's beneficial for this to be clear. You want to understand how the agreement's going to continue. Other options, what's the full term, and then how will it be ended early? How can it be ended early? And I think, you want to have that also for how you handle claims. If you're the prime, you're going to have different considerations. So you might want to push for ensuring that you've got maximum flexibility, and that would include the unilateral right to extend the subcontract. So you may say, well, look, it's not enough that the prime contract was extended by the government. That was the government's option, but I want the option to decide whether to extend the subcontract, and that because that gives me some leverage to make sure the subcontractor is continuing to perform well. A lot of primes push for a full termination for convenience right. I won't talk you out of it if that's your starting point. I think most savvy subcontractors are not going to accept the prime having a full termination for convenience right. That it should be limited to the same extent that the government might terminate the prime contract for convenience. But you can make I think a good argument as a prime. Again, it goes back to needing to preserve maximum flexibility and ensuring that you can do whatever the customer wants you to do. I think you also want to be trying to limit the subcontractor's damages in the event of termination. Let's go to the next slide. You can put some good parameters on that to really kind of hem in what the subcontractor could go after if you address that up front in the agreement. But of course, if the shoe's on the other foot and you're the subcontractor, then you want the term to continue automatically. Your position is, look, we're together for this project. I invested a lot with you to help us win this project. If the government decides to continue the project for another year, exercising the option, then that should be enough for us to stay together for the next year. You shouldn't have your own additional right to decide whether to continue the subcontract. And I mentioned the T for C before and the perspective on that. As a subcontractor, you really want to watch out for that. That's probably one of the number one things to be looking for and to push back on. I think many primes will give on a full T for C right and accept that they will have the right to terminate for convenience only to the same extent that the government terminates for convenience. I'm not saying all primes will, but I think many will, and that's a reasonable one to push back on. A more unique provision here as a sub to push for is the second bullet, that the prime can't unilaterally decide to no bid without compensating the sub. I don't know how much success you'll have in getting that in your agreements, but I mean, we have gotten them in some, and I think it's a fair point, that if you invest heavily in this effort and the prime can just unilaterally walk away from the proposal effort, where does that leave you at that point? So, all right, let's go to the next slide. We've got about 14 minutes left, and that'll give us enough time to get through the slides. And if anybody has any questions along the way, fire in here. Somebody asked a question that I'm not sure is really on topic here related to overhead and G&A. So if they want to send in some more information about what they were driving at with respect to what we're talking about here today, I'm happy to try to answer it. All right, non-competition and non-solicitation. This is the third category of common disputes that we see between teaming partners. And again, here is just examples of the kinds of cases that we've dealt with over the years, issues where the agreement doesn't have a non-compete or non-solicit. I mean, that's pretty obvious, right? If you're concerned, you're mad that your teaming partner is competing against you, and then we look at the agreement and there's no restriction on them competing against you, there may be some other avenues that we could go to form a cause of action against them. So I'm not saying you're entirely out of luck there, but if you don't even have a non-compete provision in your agreement, that's not going to be ideal. And I think I've had many clients say this to me over the years, and you've probably experienced this too, that your teaming partner today may be your competitor tomorrow. And so you want to be careful about having a non-compete or non-solicitation and how you're handling confidential information, et cetera. So watching out for one-sided provisions or provisions that are too broad. I mean, this is also commonly an issue. And I think it's acutely an issue for non-compete and non-solicitation provisions if they're too broad, because that affects the enforceability. It's kind of a state-by-state determination on what are the permitted parameters of these types of agreements. And if you go too broad, like, oh, you can't compete with me anywhere in the universe, then that's going to risk the enforceability of the agreement. I think in most cases, the enforceability of these provisions, it's going to be higher. You're going to have a better chance of enforcing it if they're more narrowly drafted. Let's go to the next slide. Or they can be not broad enough, or they're too vague, or they don't consider the applicable state law. I mean, these are kind of different variations of the things we just talked about. Let's go ahead and go to the next slide. So, all right, so how do we deal with this? So I think that whether you're the prime or the sub, this is the best advice: to be reasonable in crafting the scope and duration of the non-compete and non-solicit. I don't think it makes a lot of sense to make them any broader than is necessary to protect your interests. You can't prevent all competition. What you can try to protect against is unfair competition. So I think generally you're going to have a better time enforcing these provisions if they're tailored to the particular client or the program that you're working on, as opposed to like any client or program in the universe. And I've had some clients over the years say, well, we want a very broad provision because we view it more as a deterrent. We're never going to try to go into court to enforce it, because we hear you, John. It's probably going to be hard to enforce, but we just want to have it in there because maybe it'll deter someone. And I think that's ultimately a business decision. I just think you should not try to enforce a provision that is overly broad, because I think that could create a whole other set of issues for you. All right, let's go to the next slide. If you didn't draft it, just watch out to make sure it's not one-sided. These are provisions that I think is very fair to, if you're the subcontractor, to push back and say this should be one-sided. You have just as much interest in having protection against your people being poached as they do having their people being poached. So I wouldn't be afraid to push back on one-sided non-compete and non-solicitation provisions. You do need to be mindful of applicable state law. I gave you an example here on Virginia, but that's where your outside counsel can help you. The agreement should select the applicable law. There should be a provision addressing that. And then you need to understand in that particular state, how do you have to craft this provision to make it enforceable? A survivability clause means that it's a provision in the agreement that specifies provisions that will survive after the termination of the agreement. So a lot of times, I think almost always, what you want for a non-compete and a non-solicit is for it to continue for a period after the agreement ends. Maybe it's a year or two is going to be commonly, an enforceable amount of time. So while we're in this agreement together and for another year or two afterwards, you can't compete with me for this program, or you can't try to poach my people. If you don't have a survivability clause, then those restrictions may end the moment the agreement is terminated, and that may not be what you intended. So make sure you have a survivability clause, because I think most of the time you want these requirements to survive for a period of time after the agreement ends. All right, we'll go to the next slide here. Confidential information. I think we went one slide too far. Could we go back to, thank you. All right, so just common issues on, this is the last category, main category of common issues that we've encountered. So I'm just listing them here, so you can try to learn from your forefathers and mothers in federal contracting and not have the same types of issues, but not having an NDA in place before you exchange confidential information, so it's not protected potentially, or not having the right type of provision that it addresses the type of information that you're providing. No survivability clause again, so maybe the confidentiality applies while you're in the agreement, but as soon as it terminates, maybe it's gone. And then at that point, all the information you provided to the other side's arguably not confidential anymore. That's usually not what you would want. So let's go to the next slide, and then we'll get into some tips to address these like how have we addressed those types of things in the past. So I think you want to just be careful in considering what level of formality do you want to have for handling confidential information. A lot of times I think it's helpful to have a formal process. We're going to mark the confidential information. It's going to be stamped, and it's going to have this particular person is the one who's authorized to receive confidential information. And then when the agreement is over, this is, when you have to return it by, or you can destroy it. But I think if you're going to lay it out like that, and especially the part about labeling the information, if you're going to say in your agreement that confidential information is only information that's labeled as confidential, then you have to make sure that you're following that. You have to make sure that you are, actually putting the stamp on there. We've seen situations where, that the level of formality can kind of work against you. Yeah, and I see a question here about, can we use the NDA's terms? And I think the answer is yes. I think we will commonly use the terms of an NDA and reference it in the teaming agreement or the subcontract rather than including a brand new set of confidentiality provisions in the subcontract or the teaming agreement. So I think it depends on if you're happy with the NDA, if it's going to, provide the right level of protection and for the type of information you're going to be exchanging. You don't necessarily need to renegotiate that. You can just incorporate that into your teaming agreement or your subcontract. Again, survivability. I mean, now I'm harping on that point, but I think as a general rule, this is another type of provision that you're going to want to have be, you're going to want it to survive for at least a period of time after the end of the agreement. And this should not be one-sided. I mean, unless there's only one party providing confidential information to the other party, but most of the time in these relationships, it's a mutual exchange of information. So, all right, let's go to the next slide. All right, so I'm going to wrap up with a grab bag here. These are, I had my 4 main categories of disputes that we commonly handle, but there are other issues too, and I wanted to mention dispute resolution. So what I mean here by my little cheeky stop the fight, it's no contest, is that in our opinion, PilieroMazza, court is a much better route for resolving disputes than arbitration. And I think that you may not, if you've never been through litigation or arbitration before, good for you, and hopefully you never have to. And I think that may cause you to just kind of gloss over the dispute resolution provision, or maybe you don't care too much that it says arbitration or court. But in our experience, you can end up with some very unsatisfactory outcomes in arbitration. And you can lose in court too, but in court, you have an appeal option. In court, you're getting a judge, like they're gonna, or a jury, most of the time a judge, but depends on your agreement. In arbitration, you're picking an arbitrator. You have to pay for the arbitrator, so there's additional costs there that you don't have in court. And I think there's a perspective that arbitration is cheaper than court, and that's not usually the case. And then I think the most difficult part about it is there isn't an appeal process. So if the arbitrator goes, off the deep end and gets something completely wrong, there's very limited recourse to address that. So, I mean, yes, you can go to court to challenge an arbitration decision, but what you can challenge and the likelihood of success, it's very limited. So I think you're making a mistake if you choose arbitration because you think it might be cheaper or a more streamlined way to resolve disputes. If you're going to end up in a dispute, you're going to end up spending real money, whether you're in court or arbitration. And I just think you want the better dispute resolution process, which is court, not arbitration. So I'll get off my soapbox there, but I think you want to make sure you've addressed how REAs and claims and appeals are going to be handled in your agreement. This is very commonly left out of agreements. And if you want to have it, I think it benefits both parties usually, probably maybe more so the sub than the prime, but for it to be clear in the agreement, what happens if we've got claims we've got to submit to the government? How's that process going to work? If you are a subcontractor being offered a teaming agreement where you have to be exclusive to the prime, what are you getting out of that? I think that's a question that's worth asking at the outset of TAs. Exclusivity is a very common provision in teaming agreements. And I think it very commonly becomes an issue when clients bring us teaming agreements and say, can I get out of this teaming? I don't think I want to be on that team anymore. I'd like to go on to this other team. They've got a better chance of winning, or I get along with them better, or whatever the case may be. And I think if you too easily give up exclusivity and you're not really getting anything concrete in terms of work share or role on the project or the type of work, again, I mean, sometimes maybe you got no choice. You're going to have to agree to exclusivity, and it's a business decision you're willing to make. But I think it's important to pause at the outset, and I think then you could use that as leverage. Like, well, if we're going to give you exclusivity and not go on to any other team for this program, then we need to make sure we're getting something that we want out of this relationship. Assignment, and I know we're at 3. There's just a couple other points, and if you have to drop, I understand. But assignment provisions, this could loom large in a merger or acquisition. There could be language in here that essentially requires your subcontracting partner to approve before you go through a merger or acquisition. So if you know that you've got M&A on the horizon, you want to scrutinize assignment provisions in these agreements before you sign up to them. And then the last point I want to make here is, if small business status matters to the arrangement, whether you're a large prime and you have a small business subcontractor, or you are a small business prime contractor, maybe you have a similarly situated sub, or maybe you're just a large sub and your prime is small. I think it's important to address that right in the agreement. Just be clear. The parties are understanding who's got the status, they're representing they have it, and if there's any changes that could affect the teaming relationship, if your partner has to be small and they lose their small business status and then you lose the contract as a result, you would like for that to be addressed in the agreement rather than having to deal with that, the fallout after the fact. So I hope you guys have found this useful. Again, I appreciate you hanging in on first day. The government's back to work. I know you're all very busy, and we're glad to have the shutdown over with. And again, thank you for coming back. Apologies for the audio issue the first time. And if anybody has questions that I didn't get to here today, I know there are a few that I didn't get to, please don't hesitate to email me. I'd be happy to follow up. And again, everyone, I'll see you soon. Thank you. Bye.